Public Protector Advocate Busisiwe Mkhwebane has made her first court appearance before the Pretoria Magistrates Court, where the matter was postponed until the 25th of March. Her legal team described the perjury charges as frivolous and contrived. Mkhwebane plans to file an application to the MPA to have the charges formally withdrawn. To discuss this, I'm joined by Advocate Paul Hoffman, Director of Accountability Now. A very good evening to you, and thank you so much for speaking to us. First of all, let's talk about what you are saying. It is your view that she is fighting way too many battles. Please quantify this for us. What is too many, and are you suggesting that she shouldn't be defending herself against what she believes are erroneous impressions of how not only she carries about her work, but her understanding of the law?
Yes, I'm afraid the public protector is out of her depth, lacking in the necessary competence to be a proper public protector, and also short of honesty in the ways that have been described in the majority judgment of the Constitutional Court, which is the highest court in the land, in the Absa Lifeboat and SA Reserve Bank appeals. The complaint against her is based entirely on the findings of the court that she deliberately lied on oath in an effort to mislead the court about the way in which she went about her investigation of the complaint that had been laid by Accountability Now many years before she became the public protector. We've tried to encourage her to fall on her sword for a very long time. Had she done so when we first encouraged her, she wouldn't be in the pickle she's in now. Not only facing charges, she's also in trouble with the Legal Practice Council, who is looking into whether she is a fit and proper person to be an advocate, because advocates are not meant to mislead courts with the affidavits that they produce to courts. She's at loggerheads with the president. They're fighting it out in the Constitutional Court. She has incurred the wrath of Pravin Gordhan, one of the most senior cabinet ministers in the country.
Okay.
And then just to add,
Advocate Hoffman, let me ask you this question. Would you fall on your sword if it is your express belief that you are indeed operating within the law and its interpretation, and that you challenge those perceptions that you have acted maliciously and that you have no understanding of process and procedure?
The trouble with Advocate Mkhwebane is that her perception of the law is thoroughly misguided, and she proves it again and again. She is repeatedly taken on review and repeatedly reversed on review, either because she has been incompetent or because she has been dishonest. And when she has been dishonest, the courts have ordered her to pay punitive costs out of her own pocket. So it really is far-fetched to call the charges against scurrilous, what do they use? Frivolous. It's based on what the Constitutional Court has done.
Now, you've also described her as being between a rock and a hard place. I want to look at the various cases that you've mentioned yourself. There's the SARS incident, there's the ABSA incident, and then there are the allegations against the president. Of which do you think is the most challenging? And is that as a result of perception or the prospect of defeat in her appeal?
No, I think that her biggest problem at the moment is that she is now on trial for a serious criminal offence, which will, if the trial goes ahead, and she's perfectly entitled to try and persuade the National Director of Public Prosecutions that the majority of the Constitutional Court was wrong in finding that she deliberately sought to mislead it on oath. But the downside of a conviction in a perjury case is that she will be issued with a set of orange overalls by the court hearing the criminal case against her. And if that doesn't concentrate her mind, then nothing will.
Why would you choose to pursue this, knowing full well that there is a parliamentary process that is to ensue? Do you want to test this before the courts first, before the parliament does its work, or are you looking for a speedy resolution, as you said that you've tried to encourage her along to fall on her sword?
We complained to Parliament about her incompetence and her dishonesty in January 2017. It's now January 2021. We have no confidence that Parliament has any appetite to get rid of this public protector, and she should be got rid of. So we have had to look to other ways of dealing with her. The Legal Practice Council has a duty to see to it that those who commit perjury are not on the roll of advocates. And Parliament has its own duty to decide whether her misconduct and her fitness for office can be established in the investigation that is proceeding at a snail's pace in the face of every obstacle that her Stalingrad strategy throws in the way of Parliament. So obviously the criminal justice administration is a way of concentrating the mind of the public protector on the depth of the problem that she is in.
Do you foresee any challenges in proving any of the charges against her? Are you not at all nervous that despite what may have been ruled in the past, there could be adverse rulings this time around?
The rock and the hard place, as far as the criminal case is concerned, is that the Constitutional Court has already found, on a balance of probabilities in a civil matter, that she has committed perjury, or, as you would say by the civil standard, she has deliberately sworn a false oath. She's tried to mislead the court with the facts, or the so-called facts, that she placed before it. Now, the difficulty with that for her is that if she tries to establish in the criminal trial that she didn't know that she was doing anything wrong when she so deposed, then she is revealing her incompetence. And if she is incompetent, then she should not be the public protector.
Thank you so much for speaking to us. Advocate Paul Hoffman is Director of Accountability.